Actually, let me see. I probably should not sit right next to you.
That's you show us on 6 days.
Was all the way. All the way.
Hey, how are you? Okay. Yes.
Almost everyone's here. Miss Smith didn't make it this morning.
She may still come if you guys are still in session.
Yeah,
She doesn't want to meet us.
yeah, I'm not feeling the love.
She may still make it, Judge.
We'll see. All right, I can't add any devices. We only have the podium and the witness. So you could reach out to IT. It's not letting me.
I think it might be, it says 9 o'clock Zoom somehow.
Okay, we can get started. It's just the podium and the witness, the defense and prosecution. And when I try to add them, it won't let me. So, all right. Good morning, everyone. We have a plain arraignment calendar this morning and a little dash of probation revocation potentially. Before we dive into it, so we still don't necessarily have a lawyer for this guy. He has 3 cases on the calendar. Who is she coming?
She's gonna talk about it. Yes.
She's going to be here.
I don't know.
Okay, because he comes and every time he comes, it is a problem down in the basement. So I don't want to bring him again until we know she's going to be here. All right. Position 1 is State versus Yarber.
He would be mine, Judge, if he shows up.
Okay. No luck reaching him.
No, Judge, and I thought he might be in a different institution, but I haven't confirmed.
You haven't been able to find him.
Correct.
All right. So does the state want a bench warrant if Mr. Yarber doesn't show?
Yes, Your Honor.
Okay.
Right, I'm not gonna be upset.
Gregory Sigmund.
He would be mine if he appears, then I have contact with him.
Okay, he bounced from non-complex. Let me see if he had court there or if it was just straight sent. No, it looks like he did have some court that he made. So, all right, bench warrant for, oh, he has a W next to his name. That may be why he's not showing up. Can you check on that is? Thanks. Christian Falconer.
Hold it for a while. Let us know as soon as you're available to come back in, okay?
Thank you, Judge.
Thank you.
Yeah, thanks, Mr. Patterson. Okay, Mr. Falconer?
It's ready. Mr. Knowles, we're ready.
Going once, going twice. All right,
Finance the state will request a bench warrant, Your Honor.
3 for 3. Mr. Roberts is here. We're waiting to see if we can get a lawyer to show up. How about Notarius Smith?
I have not had contact.
Here, no response, Your Honor, the state will request a bench warrant.
Okay, he may also have another warrant out, which may be why he's not here. All right, Tyrus Brown. This calendar did get published?
Yes.
Okay.
Private on that.
And well, it's a peculiar one too. He does like motions for new trial and stuff like that. Hey, Ms. Rivers?
See if I have it.
He filed an entry, so it's legit. Okay.
Double check, make sure I don't have it.
Okay. But
For Mr. Brown, hearing no response to state, we'll request a bench warrant, Your Honor.
all right, Cody McGlone. Maybe can we have a prize for the first defendant who shows up with like a discounted plea?
We would ask for a bench warrant for Mr. McGlone, but I also wanted to bring to the court's attention that he also has another case that it looks like was indicted after this one and is assigned to Judge Schwab.
Hmm.
That's 25, and it's the same victim.
Oh,
It's 25 SC 006410.
thank you. So we'll get that. So they can all be in one place. Okay. He got a bond, all that. Ms. Rios filed a substitution of counsel. All right. So bench warrant there. Terrell Bond.
Right, for a bench warrant.
I don't recognize the attorney name. Is that a one you recognize, Ms. Rios?
So many people.
So,
That's a private attorney.
because you've been around for so long. That's a private attorney?
Yes, Your Honor.
Okay. The veteran public defender. Yeah, it is. And he just filed, just like a week ago, filed something. Okay. Bench warrant. Bench warrant. Danielle Willis.
She's my judge. She was excused from appearing. I waived agreement and updating her address in the court.
Okay.
I don't think that W is accurate.
Okay. All right. Thank you.
You're welcome.
You read my mind. All right. So you did a waiver.
Yeah.
Waive and schedule. So that sort of counts as like, she's not here, but it's okay. Yes, you could, I don't know where the candy dish went. Put it on your table.
But it ended up on my desk.
Yeah, they had mock trial here this weekend. Everything was jacked up. Sorry, they ate most of it. Yeah. Corell Turner. Mr. Patterson, this is your case. Just like that, he dropped off. Didn't you see him? He had the blazer on and everything. Hopefully he'll come back. Elijah Kitchens.
He's in custody in Cobb County on their charges,
Okay.
so not alone now.
Will this be your case when we get him here?
I'm assuming, I don't see an entry and I don't think he has an attorney for his Cobb County cases, so I'm
Okay.
assuming yes.
All right. Omarion Lee. So there are a lot of people here and no one here is for, all right.
Hearing no response, state will request a bench warrant.
Okay. All right, we'll come back to it. Jalen Chambliss. Oh, he's not here yet. Is he on bond?
He is not going to be here in person. The facility he's been moved to Marietta
Oh,
RYDC.
okay.
They are able to log on Zoom at 11 if the court allows them to.
All right. Well,
His
we'll,
lawyer, I just sent the link to Ms. Williams.
great.
LaToya Williams.
Okay.
She'll be on shortly. But the court can just direct me as to whether or not would like him here at 11.
Who is covering, this is a Mr. Hiles case.
Good morning, Judge. ADA Smith, Demetrius Smith.
Hey, Mr. Smith.
How are you?
I'm well, yourself?
Doing well.
So one Smith showed up. All right. Are you inheriting Mr. Hiles's caseload, or during his absence, you'll make sure his cases move forward?
I'm one of the attorneys who will be covering his caseload.
Okay. But for today, you're the gang prosecutor to handle the arraignments. We have some tomorrow as well. He has a big case that, unsurprisingly, and the arraignments are coming across 2 days.
Okay, no problem, Judge.
Will you be back tomorrow, or will it be someone else?
I will be back tomorrow.
Okay. Demetrius?
Okay, thank you.
Well, what we'll do at 11, in theory, Mr. Chambliss will be on from that YDC, but we got a couple more. And then if you just want to be back at 11, that would be great. Well, we got to make sure his lawyer can join then as well.
Understood.
All right. Nicholas Shannon. Mr. Shannon is here. All right.
She does have a penis attorney, but she had hoped for the report. I didn't get her name.
Okay. Mr. Shannon, have you spoken with a lawyer yet? What's her name? Can you spell Warlick? All right. We've met her before. And she said she'll be here. All right. So Ms. Warlick is going to be here. We're going to sit tight till she gets here, and then we'll talk about your case. Pardon me? There she is. Hey, Ms. Warlick. How are you? We just got to Mr. Shannon on the calendar. Do you want a minute, or are you ready to talk about arraignment?
I don't even know you're on. I'm good to go.
Okay. There's a,
We don't have an injury. Okay, let me go.
just give me 1 second. We look this up. Shannon. Ms. Warlick, this is a re-indictment. I know we've interacted some, but may have been not this case at all. Were you Mr. Shannon's lawyer in version 1 of this case, or are you new to him and you were? So this is a carryover for you.
It is. And I was just trying to figure out what happened with the notice. Did everybody receive? Because I only got notice through.
You wouldn't have received notice because when Mr. Howells re-indicted it, it's a brand new indictment number. So you'll need to do an entry. We've got a form right here for you to use for this case number. And then you'll be his attorney of record. You didn't stop becoming his attorney of record. It's just that the system views this as a brand new case, even though 98% of it was drawn from the preceding indictment. So if you'll fill out a entry of appearance, you also can do the waiver of arraignment, assuming Mr. Shannon wants to waive arraignment. Okay, so 2 forms over there. And have you already, Mr. Howell sent an email out to all defense counsel saying, bring a hard drive and I'll fill it.
We've done that. I think we're in the queue somewhere.
Okay, to be filled.
Yes.
All right. Mr. Smith, how is that operating with Mr. Howell's out of pocket? Is it still happening? These hard drives are being filled?
I would have to double check. I'm not sure if we received defense counsel's hard drives yet.
I know you've received some because for whatever reason, I was copied on one. Mr. Howell sent an email out to all the lawyers and copied me. And at least one of them said, hey, I just left the hard drive. I've got tape all over it saying it's my hard drive. And he said, those things are underway. So I'd ask you to check with the team so we can give Ms. Warlick an update before she leaves today about when she might get that hard drive.
Yes, sir.
Great. Sure, yeah, you can go. I don't know that, again, we are not doing these mock trials anymore. All that stuff got messed up. But we'll get you the 2 forms.
Your Honor, I thought I saw something in the system as a result of the indictment, and I just want to make sure there wasn't any other issues.
There may be, this is what I'm asking, Ms. Nelson to check out. So which form do you have, Ms. Warlick?
I have the, waiver of the declaration of discovery and everything else.
Oh, it's all one form?
Yes.
Well, perfect. You've got the right form. All right. If you would work on that.
Not reaching out to me.
Okay. It may, I don't know if it,
It's because man,
yeah, and it's just, okay,
that's what I did.
okay. So let me find the previous case. So Ms. Singleton, Mr. Shannon has been under your supervision under the previous indictment. Any issues to date?
No, he's doing quite well. He actually just finished half the full semester classes and half a semester
Fantastic.
waiting, and they're getting ready to get in the next step.
Great. All right. Mr. Shannon, how are things going with bond? Okay. Any conditions that are particularly difficult that we should talk about, or you're okay right now with the status quo? Okay, who are you here with? Okay. Well, we'll leave them as is for now. Ms. Warlick is who you should talk to if there's a bond condition that is real difficult for you. And then she can talk with Ms. Singleton, and we may have a group discussion if we need to change anything. You've been on this bond for a while now. Was that almost 4 months? And I don't know when you were able to post bond. I issued the bond in July, but until the bond order changes, you got to do everything it says in there. And it's kind of strict, but appropriately so because it's serious charges. Okay. I know you know, and Ms. Singleton says you're doing great. So you want to keep that up and then obviously stay in touch with Ms. Warlick. The last position is just a co-defendant Maloney. Is he in custody or?
Yes, Your Honor.
Okay.
He's one of the ones.
So he would be here later today, but in person.
Yes. He's ready to move now.
Okay. It's Mr. Chambliss who got moved, and we'll see him virtually.
Yes.
Okay. Anyone in here who didn't hear their name called, as in you came late or you just didn't hear the name?
Good morning, Judge.
I'm sorry.
Good,
Go ahead,
good
Jay.
morning. The fly lawyer for Mr. Turner. Good morning, everyone.
Hey, Mr. Patterson, you are here for Mr. Turner?
That is correct.
Do you know where Mr. Turner is?
Should be in custody.
All right. Well, let's see if we can get him out here and handle his arraignment.
Not a problem. Your Honor, if it'll save the court time, we certainly just plead not guilty and waive formal arraignment.
Well, it won't take much time. I just want him to hear that since he got brought all the way over here. So we'll get him. If you could do that, that'd be great. Thanks.
That would be fine. And Your Honor, also, we would need a bond hearing date. We filed for a bond as well. If the court would give us a date, that would be great.
Okay, I will talk with Ms. Nelson and she can put this down for a bond hearing. I'm pulling up the docket right now. There he is. Okay. Hey, Mr. Turner, you come right up to the podium here. Morning. I'm doing all right. How are you doing? Good. Your lawyer, Mr. Patterson, is on the screen there. He has a bunch of different courtrooms he needs to be in, so we let him pop in virtually. Today is your arraignment day. That's when your attorney lets me know if you're entering a not guilty plea or a guilty plea. It's usually not guilty at this point, and he's already previewed what the answer is going to be. He also told me that he's filed a bond motion. We're not hearing that today. It wasn't put on the calendar for that, but he did ask that we get you back here soon so that we can have a discussion about bond, either to set a bond if you have none or to lower the bond because you're still in custody, so the amount isn't something that you can make. So Mr. Patterson, is Mr. Turner waiving arraignment?
That is correct, Your Honor.
Okay, we will get you a waiver of arraignment form that you or your team can fill out and get back to us so that can be made part of the record. And that's where you can indicate whether you're opting into discovery, and that will move the case along. We'll get a scheduling order right after the waiver of arraignment is filed. That'll have a deadline for the state to get you discovery, a deadline for you to file substantive motions, and it will ensure that the case keeps moving along. Separately, we'll schedule a date for a bond hearing.
Thank you, Judge.
You bet. Anything else on behalf of Mr. Turner?
Not at all. And it's always great to see your fair and just prosecutors in the courtroom.
Well, I don't know that you can see them. On the screen, you can see your client and a fair and just public defender. But they are in court and they stand ready to get you discovery and engage in the litigation that needs to follow. Anything from the state, fair and just?
Nothing from the state at this time, Your Honor.
All right. I thought you were going to say something nice about me. It was about you guys.
Well, no, Judge, you're the
It's a little
fly
bit of a
judge.
letdown.
No, you're the fly judge.
Yeah, I found that was already trademarked, so I got to come up with something else. All right, Mr. Patterson, thank you for dialing in. We'll get you that waiver form. Please get it executed soon. Oh, Mr. Turner, any questions before you and Mr. Patterson go? Okay, I'll see you soon about bond, okay?
Thank
All
you.
right, bye-bye. Position 3 is back there. You are Mr. Falconer? Hey, how are you? You're back. You were gonna hire, you told me Miss Taylor's retiring. She's still retiring? Okay, and you were gonna get Mr. Matthews. I won't tell the lawyer you forgot his or her name. Sorry. Yeah.
Hi,
It's green.
it's actually, it's me, Jade Green.
Oh, it's Jade Green on the screen. A little awkward. She's right there. Like, yeah, there's this lady. She's my lawyer. I have no idea who she is. All right, why don't you come on up to the podium, Mr. Falconer, and then maybe you'll recognize the face on the screen. All right, we're all in one place. You're tall, so he's got to adjust the screen there. There we go. All right, Ms. Green, good morning.
Good morning, Judge.
Have you filed an entry yet?
I believe we filed it yesterday. We were retained yesterday, so it was probably in the evening at some point.
Yep, but it's in. I see it. So you are official, and it looks like you did a waiver as well. Very thorough. Thank you for doing that.
Yes, Judge.
We will get a scheduling order out in the next day or two. That'll give the state a deadline to get you discovery, and then you'll have a motions deadline to take care of any substantive motions, if there are any in this case. It'll have a final plea date, things like that.
Okay, perfect.
I think we've taken care of everything. Mr. Falconer, any questions about anything? Okay, so no bench warrant for you. You showed up. You've got a lawyer now. Did you get something in the mail telling you to be here today? Good. So we've still got a good address. Your lawyer will be getting notices as well for whatever's next in court. She'll be reaching out to you to say, hey, we've got court on this or that. I want to see one thing and then I'll let you guys go. You've got a co-defendant. I want to make sure that person already has a lawyer and it's moving along. Yes, she does, and it is. So there we go. Okay. Anything else, Ms. Green?
No, Your Honor, that's it.
Okay. Anything from the state in this case, position 3?
Nothing further from the state, Your Honor.
All right. You'll make sure Ms. Smith gets discovery to Ms. Green.
I will, Your Honor.
All right. That's it. You're good to go. Take care.
You can be dismissed.
Yes, ma'am.
Thank you, Judge.
Okay, Judge. You have.
Hey, Ms.
Eugene
Cabrera.
Roberts. Hello, Judge. How are you?
You were very patient letting these people kind of move
That's
by you.
okay. That's okay. So it looks like Mr. Eugene Roberts is on the calendar. I had him on the calendar, on my calendar for the 30th, but I realized it's just a typo in how Ms. Nelson saved the calendar. So I had it on my calendar for the 30th and not for today.
Okay.
But I don't know how many cases he has on the calendar. I do know I don't have everything he has. So it sounds like he has multiple things, and I have something that ends in 250 and something that ends in 848.
So I will get you up to speed on Mr. Roberts. First and most important, he's sour about something. Whenever he comes over here, it's not a fun event for the deputies down in the basement. And maybe it's because he wants to connect with a lawyer. I don't know. 2, he does have something that ends in 250. That is a closed case from Judge Ingram for which he is on probation. And the basis for the revocation is at least one, if not both, of his new cases.
Right,
So
and that was his probation revocation. And so I wasn't formally sent the probation revocation, but I think the last time he was on the calendar, I agreed to handle it.
Okay.
Since it was, I can't, it doesn't make sense to not handle it. So I
Right.
agreed to handle that. So I do have that one.
Right, and we really wouldn't do the revocation independent. I mean, either would be
Right.
a mini trial of these new charges, or it would be a global resolution.
Right.
But let me give you the 2 other cases. What was the other case you said you had?
I have something that ends in, I think it's 848.
Yeah, so 25 SC 004
And I filed
848.
into that one, and I filed into that case and filed a waiver in that case. And then I think there's something else. When Ms. Nelson emailed me this morning,
Yep,
her
there's one
subject
more.
line has a completely different case number.
Yep, there's one more, and that is 25 SC 005788.
Yeah, I saw that in the email.
And that one is an entering auto and some property crimes. It was in non-complex and it got transferred here because probably Mr. Roberts has the older case.
Okay, it's
Yes, because of his older case. So it's 2 cases that are new, meaning open. The one in 848, which is a theft by receiving. And he's got a co-defendant in there. And then this other case that I just gave you, 788, he has a co-defendant as well.
And that's the one that I don't think is mine yet. So I have to find out what's going on with it. I can't imagine that it won't come. It just
Yeah.
hasn't been formally sent to me yet.
Okay. So what should we do so that you and Mr. Roberts can connect? Should we have him come back on the 30th? Would you know about the 788 case by then?
I can ask about it. I don't know if I'm gonna have an answer by then, but I can ask about it. You have another calendar on the 30th? What else do we have?
On the 30th is a final plea calendar, but we could add Mr. Roberts to it if you were going to be here. If you weren't going to, I was only throwing that out there because I thought you were going to be here because you thought that's when this calendar was.
I can't remember. I'm in Douglas County right now, but I don't have the I don't have my calendar sitting beside me.
Well, why don't you
I
work
can
with
email
Ms.
Deidre.
Yeah, just let Ms. Nelson know when you will next be here. I think it would be good for you and Mr. Roberts to be mano a mano.
Okay. I can let her
Um,
know that. Hopefully I'll be done here within the next, I don't know, hour and a half. They're waiting for me to step back in. So hopefully I'll be done by then, and then I'll be able to go through my calendar real quick and then let Ms. Nelson know exactly when I'm back in your court.
Okay, sounds good. Thank you.
Thank you, Judge. And thank you, Deidre.
Bye-bye.
Bye-bye.
Mr. Brown? Hey, Mr. Brown, how you doing? You're good right there. Hey, you know where your lawyer is? You do? There was a lawyer who filed an entry in your case. What? Okay, well, it's a two-way street. You can reach out to the lawyer, which you're gonna do in just a minute. He filed an entry in your case in July of last year. Filed a bond, you got a bond, you had a preliminary hearing, and now you've been indicted. It may be that he didn't agree to represent you beyond that stuff that happened last July, but here we are. And he's listed as your lawyer of record. So this is the morning when we're going to sort that out. So you should reach out to him. And he may say, I'm not your lawyer anymore. If you qualify for appointed counsel, you could talk with one of the public defenders here today. It may be you want to keep the lawyer that you had before, but we need to work through that this morning, okay?
I had already talked to a public defender, I told him that I was, he was my representative.
Okay.
So I just need to go down there and just.
Not necessarily. We've got two right here. Your case ends in an 8. So Ms. Rios, will you chat with Mr. Brown? All right. So if you'll take a seat, Mr. Brown, Ms. Rios will talk with you and we'll figure out what, if anything, we can do this morning with your case. Okay? Thank you. Hey.
So I submitted the entry, I did speak with the state about just confirming that I am in the queue for the discovery.
So they've got your hard drive. Excellent.
So I think I can move my business unless there was some apprehension of there being some sort of issue.
Well, I think there is an issue writ large in that technically, Mr. Shannon doesn't have a bond in this new case. That is not his problem yet. I'm gonna let him go, especially with Ms. Singleton saying he's doing fine. But this happens when the state reindicts. The bond was on the old case and the new case has different charges, maybe no new charges for Mr. Shannon. But we just need to work through how we can import the bond from the old case. Now, the old case has not been dismissed, so it's still an open, active case, and that bond still has all the teeth and conditions that it should. And that may be how we limp along for a little while, is that the bonds that the people who did get bonds in the previous case keep those in place. But we'll need to figure out what to do about the bond situation. And it may be, it is not meant to be a new financial imposition on your client's family. So I don't know how we work that. But what I've done in the past, if it's like a sheriff's 10% program, and I can't remember if this is through a bonding company. Do you guys get a bond through a bonding company or through the sheriff's? So that may be more flexible where I just create a new bond. It's the very same dollar amount. It may just have to be spread out differently. I don't remember if Mr. Shannon has different charges in the new indictment. But whatever his situation was, that bond was appropriate then, and the indictment is a new document, but it's not new conduct. So that was just the hiccup we were working through, is that there was an indication that Mr. Shannon didn't have a bond, and technically that's correct. But if he does not have any new charges. Okay, so it's a 1-to-1 map. So we'll need to work with the sheriff's office to see if there's a way to have effectively that same bond move over. Certainly the dollar should be able to move over. But for now, nothing for you all to worry about. You focus on getting your hard drive back.
Batman, excuse your.
Sure, Mr. Abadi, did you have any other updates on the case?
No.
No, just that he didn't have new charges. Okay. Mr. Shannon, any questions? Okay, well, keep doing the good stuff you're doing. Stay out of trouble. We'll see you in court soon.
Any kind of way that people can come home,
Pardon me?
it's any kind of way that he can come home,
When you say come home,
like come to my house where he was raised up at.
okay, let me take a,
Hey, court told me that he was gonna see if he can come home.
so let's see, you've got an ankle monitor. It doesn't say where you're supposed to live. Ms. Singleton, what do we know about Mr. Shannon?
He was to live with his father.
Okay, and that was,
I was informed by the court, he was to live with his father, and that's where he lives.
okay,
I believe that he could not go live with his grandmother either because it's in the area of the incident location or because he was living with her at the time of the incident.
okay, got it.
And so he's been in his father's house the entire time.
All right, are you able to visit your grandson is this your son or this is?
I raised him.
Okay, either way, so but you're able to visit Mr. Shannon?
I have a hard time going back and forth. I have a hard time taking grocery back and forth. But the last time we was here, that you had made a statement that you made to let him come home.
Okay, tell me more. Did I just say he could go home or if he did well on bond for?
He did well for us, like going to school, what he's supposed to do.
Okay, and it sounds like he's been doing well. That makes me, I think that's good news, but if that says to me, he's in a good spot right now. Things are going well. I'm not saying that where you are is necessarily a more complicated spot, but if that's where he was living when all these charges happened, then and I see how he's doing now, you can see, well, I don't know that I want to rock that boat a whole lot, but why don't we do this? Why don't we come January? So let's get through the end of the year. And then you should talk with Ms. Warlick and she can reach out because that's really how the conversation should go. And then we can have a discussion about, frankly, what's in Mr. Shannon's best interest. I don't mean to make your life difficult because it's hard to get back and forth, but my focus is on how do we keep him out of trouble between now and resolving. These are serious charges. And if he, I'm not saying you would do, but if he messes up and all of a sudden he's where he's not supposed to be, then I'll put him back where these other guys are. And because this case has so many defendants, it's going to take a while before we get to trial. And so he is.
But could he be with the family for the holidays, Thanksgiving, Christmas?
So your question is like on Thanksgiving Day, could he be at your house rather than? So that's different than moving back in. I don't think that's as much of a problem. What do you think, Ms. Singleton?
No, I was initially requested that he go stay at an Airbnb, which is where the family will be celebrating the holiday for a period of days.
Okay.
And I can't get permission for him to stay out overnight. So I instructed Ms. Jolly to contact his attorney.
But if his dad is at this Airbnb, would he stay home by himself?
I was under the impression that his dad was going to be at this Airbnb.
Oh, he's not. Dad is staying home. Okay.
This was going to be with grandmother and other.
Got it. And so it's the overnight part that is the, right. So I think the way we would work something like,
Stay overnight.
right, exactly. I think the way we could work Thanksgiving would be as long as Mr. Shannon is letting his lawyer know, so the lawyer is letting Ms. Singleton know, hey, I'm making these times up, but from 9 a.m. to 7 p.m., Mr. Shannon's going to be at because we know where he is. That ankle monitor tells us he's in courtroom 8D. He's at the Shell station. He's at home doing homework. So if he goes somewhere on Thanksgiving, we just need to know in advance where it is. And there just needs to be brackets around it. So like I said, 9 a.m. to 6 p.m. or whatever fits with when the family is going to be together. But it's not 9 a.m. Thursday to 9 a.m. Saturday. It's not an overnight. But I don't see a reason to be concerned about family together time, with one caveat. There are a whole bunch of young men in this indictment. I don't know if any of them are cousins but none of those guys could be at your Thanksgiving event. One of the conditions is no contact with any of the co-defendants. So I don't know if any of the other co-defendants spend Thanksgiving with you.
No.
No? Okay. Then that seems workable. Again, no sleepover, but that's probably a great way for him to reconnect. All right, Ms. Warlick, anything else?
No, Your Honor.
All right, thanks, everyone. All right. Mr. Lee? Hey, Mr. Lee, how you doing? If Ms. Gibson had the case, does that mean it's a conflict case?
Yes.
Rats, okay. Come on up to the podium, Mr. Lee, please. How are you doing? Good. I'm trying to figure out an attorney for you. So Ms. Gibson works for GPDC, but she gets brought in because there's a conflict?
Yes.
Okay. So Mr. Lee, I'm Judge McBurney. Your case has been assigned to me. The lawyer did you ever meet a lawyer in your case? You remember meeting anyone? It was a little while ago, but someone was appointed to represent you. But she was handling things before indictment. And for some reason, I don't know what it is. Oh, you had co-defendants originally. That's why. Before this was indicted, there were two guys who were in the mix with you, a guy named Vincent Russell and Jacoby Johnson. And that guy had the public defender. So we need to get you a lawyer unless you're planning on hiring one. Do you need a lawyer appointed? Is that yes?
Yes.
Okay, we'll do that. So we're gonna need to get you to come back here. I just want to see what your bond situation is. You got to stay away from a couple people and an address on Piedmont Avenue. So that's not particularly complicated. I've got an address of Benidorm Court. Is that where you live? You look sideways when I ask. Like sometimes you live there or
It's off and on.
off and on. If mail gets sent there, do you get that mail?
Yes.
Okay, because really I'm asking, the only way you're going to know when to come to court till you get a lawyer, we're actually going to give you a day today. You leave with a piece of paper since you're off and on at that address. But that's where we mail stuff. Who lives there?
My grandma.
Your grandma. Okay, and she'll let you know, hey, grandson, you got some mail. Okay, all right. When you're not living there, where are you staying?
My little brother mom.
Okay. All right. Are you in school?
Yes.
Where are you going?
Skyview.
So you're missing school right now?
Nah.
Is Skyview online?
Nah, I do afternoon.
Afternoons. Where is that?
Oh, national.
Okay. So it's just in the afternoons?
Nah, you can do morning section or afternoon.
Okay. All right. Do we have a date, Ms. Nelson, that we can give Mr. Lee?
You're gonna have someone represent or is he?
He needs Ms. Cabrera
Okay.
or a conflict attorney. I mean, he's the only defendant on the case, so I think Ms. Cabrera could do it. But he was originally in a PI case with two others, and the public defender represented one of those two.
It'll be, November 12th.
At what time?
1:50.
1:30? You're gonna actually give him a notice? Oh, I was gonna give you this informal notice, but
Whatever works for the court.
no, well, this is ready. So this semi-formal notice has the phone number for Chambers to call if something comes up. It's got the date you're supposed to be here, November 12th, which is a Wednesday. So 2 weeks from tomorrow at 1:30, and it lists the courtroom. Because you found this building, so you need to be back here. So that would be a day where you go to school in the morning, not in the afternoon. We will have a lawyer here for you. You guys will meet, exchange contact information, all that kind of stuff. And we can get your case rolling. You know what you're charged with?
Yes.
Okay. And your lawyer will talk with you about that, but we can't start the process of moving your case along until there's a lawyer to advocate for you and to deal with the state. Okay? Any questions?
No.
Can you read my handwriting?
Yes.
Okay, don't laugh. All right. So what day will we see you?
November 12th at 1:30 p.m.
Courtroom AT. See you then. All right. Anyone else show up late? Nope. Okay. Is Eugene Roberts up? He's cool. Okay. Would he benefit from being told we're going to get him as lawyer? Or is it better that we don't chat? Or you want to tell him? Okay. Can you just come to the door? Did he naturally become cool or did you make him cool? Hey, Mr. Roberts, how you doing? What's up is I talked with the person who's going to be your lawyer. She did not know that you had another new case. So she's got to fill out some paperwork so she can represent you on, you have two, I say new, they may be old situations, but you have two indicted open cases. They're with me. You've got the old case, you took a plea in front of another judge. That's moved over here because there's a probation revocation based on the new conduct. You've got co-defendants in both your new cases, young lady in one and a guy in the other. Most importantly, we need to get your lawyer here. So she's going to be available in the next few days. We'll bring you back so you can be here with the lawyer and we can figure out how we move in Mr. Roberts' cases forward. Okay? Any questions about that? No? All right. I know you're stuck. So I'm trying to get you connected with the lawyer so we can figure out what we're going to do with each of these pieces. I will see you soon. All right. Let's turn then to we had a walk-in plea.
I believe it's on, I think I saw him on.
He's there. I don't know who the defense attorney is.
It's me.
Okay, so we could do Mr. Morris. We also need to talk about the gentleman with the sentencing woes.
Yes.
He got brought over, but let's just figure out what the plan is with the revocation calendar. We've got Larry Arnold.
I'll be working with Mr. Arnold today. We should be able to take care of that. There's just one little issue I need to talk to probation about.
Okay, how much time is left on Mr. Arnold's case?
5 years, 7 months, and 29 days.
Wow, from a 2011 case. All right. I don't have anything. Oh, I do. I have him. It's Holly. You sent me Holly, so now I've got Holly as well. And Holly would be a Rios production.
Yes, I will be asking for a reset because we want some services. And I already sent in a social worker last week to try to get him some, so I want to see if we can do handle him later once he gets accepted somewhere.
Okay. Do you envision this as one where we are going to have an evidentiary hearing, or he's not interested in doing that?
No, we're asking to see some services for him.
Okay. Let me see his petition here. So some of it's technical, but one of it is couple new sets of charges. Okay, have those been indicted? Okay. Well, let me ask it a different way. Have you talked with the state about what the state might be recommending?
Yes, briefly, she said she had to look at it, and then I also talked to Ms. Simpson, she told me what she was going to recommend.
Okay, but aware of all those data points, you and Mr. Holly want to go forward with a, hey, it's just negotiated, but we're not going to contest the allegation. That's all I want to know is, does the state need to bring in
No,
officers?
From my understanding of the conversation, you just really wanted some, beneficial.
Okay, if we just bring Mr. Holly to the door, please. How far out do you want it set? A few weeks, a few months?
1 month.
Okay, circa 1 month. There's a time of year where that's it might be a little more than a month, but we'll see. Should just be one. Oh, Ms. Singleton, I thought that, is Chambliss here? I thought it's just Maloney. Okay, Chambliss, she said, got moved and it's gonna be zooming in. What case are you guys here for? First row. In, in the case with Chambliss, et cetera, et cetera. Okay, well, welcome. It's going to be kind of uneventful today. It's an arraignment day. You are welcome anytime we have court. With this many defendants, there will be many, many days of court, and you may want to work with the victim advocate to get a sense of when is there going to be more substantive work. But any day we have anything going on, you're welcome to be here. There's also always a feed that you can watch if getting here is complicated. So you can be watching it real time, just not from in the courtroom. So you were aware that the case got re-indicted? And that's today, and I guess tomorrow. You can be back tomorrow if you want. The inmates will all be virtual tomorrow. They won't be coming in. They're going to be, tomorrow is all inmates. And so they'll be appearing from booths out at the jail or at a YDC, depending on their age.
Probably my fault. I had, just in case there was a pop-up bond hearing, the defense attorneys tend to file and ask for, even though they're not on the calendar, why I requested.
Okay. Well, and I welcome you every time. When we have something as serious as what you all have been through, I tend to resist pop-up bond hearings, but Mr. Abate is a victim and veteran of those. Sometimes a lawyer will say, but hey, we're all here. Why can't we talk about bond? And one answer is because there are victim family members who aren't here who ought to be heard from. And so I tend to push back on the surprise notion of that. This is a case where, at least so far, the lawyers, the defense attorneys have been pretty good about saying, here's what I'd like to do on day X. So when we come into court, we know what's going on. I don't think we're revisiting bond tomorrow, but I don't know. That would be on the calendar. But tomorrow, again, everyone is in custody, and they'll be appearing on screen. I'll be here in court. You're welcome to be in court. It'll probably just be us who will be in court. You won't see people coming through the doors. Yes, ma'am. How many defendants are coming in? Good question. I'm gonna let Ms. Nelson check that. I don't want to leave Mr. Holly standing right here, so we'll answer that. Mr. Holly, how are you? Good. I was talking with Ms. Rios, your lawyer, and she was explaining to me that she thinks, and I think you agree with her, that it's important that you and people on her alternative sentencing social work team have a chance to look for programs for you so that Ms. Rios has something to recommend different from what the state will likely recommend in your situation, which is probably revoke time. I'm looking at your petition and there's a bunch of allegations, and the state often says, hey, based on that, revoke 6 months, 9 months, a year, whatever they're going to say. And Ms. Rios wants to be able to say, not just less time, Judge, but here's a program for Mr. Holly, STAND or Georgia Works, or I don't recommend any of them. I am open to whatever they may be. But that requires a little more time. And will it be Ms. Ross who would meet with him? And for Ms. Ross, who is a colleague of Ms. Rios, to come talk to you about what might be a better fit or a worse fit. So we're not able to move forward with your revocation today. We're going to reset it a few weeks and get you back here after you and Ms. Ross have spoken and she's been able to identify an option or two for you that's something other than custody. Does that make sense? Any questions about that? Okay, I'll see you soon. Thank you. 6 is the answer. Yeah. So I didn't know if Mr. Abadi was talking with you. Ms. Wood, do you want to do the plea now, or do you want to do Mr. Arnold now? Or do you want to do, well, I would vote for the gentleman who's stuck on Zoom before we do folks in.
I'm texting him an update real quick.
Okay, that's fine. All right, so position 1 will be a bench warrant. Will you keep track of this? Because I think your team needs to send those to Ms. Nelson. Position 2 is a bench warrant. 3 is not. 4 is not. 5 is a bench warrant. 6. Oh, we got to.
He stepped outside.
Yeah, we got to circle back with him. 7 is a bench warrant. 8 is a bench warrant. And that's it for bench warrants so far. Mr. Abadi, I'm going to interrupt you guys for a second. It's 6. 6 defendants will appear via Zoom tomorrow for their arraignment. I mean, this is assuming their lawyers plug in as well. You will quickly learn that this process will move more slowly than a one defendant case because these lawyers are spread all over the place. They get these calendars, and a benefit of Zoom, even though it's impersonal, is that they can Zoom in, like you saw, not your case, but that woman who was in Douglas County. So they might have something in Clayton, but they can still join us for a few minutes so that we can do the arraignment, which will then move the re-indicted case along. Will you be plugged in for it tomorrow or someone else covering it? Okay, great. Mr. Maloney is here. I thought he had like Max Sharp, or did he not have a lawyer yet?
It's on Regas.
Oh, it's Regis.
And Mr. Regas has a conflict, however, they just had me send the Zoom link to Aisha Broderick,
Okay,
so she should be coming on.
jumping on for Maloney.
Get an ETA, they're getting ready to bring him out, I told him that he's here.
Okay, well, we won't bring him out until you know that Ms. Broderick can jump on. But you could let them know as soon as she gets on, we can bring Mr. Maloney out.
And Maxwell Sharn. Miles. Right.
Okay, I knew he had one of them,
Okay.
not that guy.
It is.
Okay, good. The more the merrier.
You about to take it, you know, we're going to take, huh?
I didn't miss a court date. I knew that there was like a pending wait to see if he can move in with this other person, and I needed to check him out. But then I saw the order in there denying the bond, but I
Right.
never did come to him.
There wasn't, it was,
I wanna make sure I didn't miss that.
no, it was, yeah, it was under advisement, and then I ruled that bond was not appropriate for Maloney. So he's in custody.
Just making sure.
Yep. What's the name? It's Mark Morris. What's the case number?
5 SC.
I was gonna watch you.
25 SC 002463. And it's only in count 1 and 8. All the other counts are being.
Counts 1 and 8. All right, thank
And I'll
you.
put it on the record, but.
Okay, so give me a heads up.
I thought it was a female.
Yeah, because, isn't this?
He's gonna tell you who's the
Oh,
podium.
it's fine.
Hmm?
We have some.
Yeah.
Yeah, spicy girl.
We do.
Yeah.
Yeah,
Yeah.
And
York is on.
I'm working on their stuff today.
Okay.
Pretty sure. Let's see what judge says.
You know, she's gonna
We're doing more.
roll out the way.
We are. And then we can bring Maloney out.
Oh, no, we need to ask for the.
All right.
Yeah, I've got those tomorrow.
Ms. Wood, are you ready to go with Mr. Morris? All right, Mr. Morris, can you turn your camera on? There you are. Can you hear us?
Yes, good morning, Your Honor.
Good morning. Thanks for being patient. Where are you? You're all bundled up. You in Alaska?
No, I'm right here with my father.
Okay. But where is here? You in Georgia?
Yes.
Okay, excellent. Well, let's go on the record. And pre-trial, I'm gonna give you the case number in a sec. This was not on the calendar, but I will need some criminal history information on Mr. Morris in a few minutes. The case is 25 SC 002463, State versus Mark Morris. And as I understand it, it's a plea to count 1 and count 8. And the other counts are being dismissed by the state. Mr. Morris, we can take a remote plea like this, but I need you to tell me before we go any further that you're waiving your right to be here in court and that you're okay proceeding from wherever you are with your dad.
Yes, sir, Your Honor, I waive my right.
Okay, you also have the right to have Ms. Wood right next to you, so you could lean over and ask her a question. She's here in court. You can see her shoulder on the screen there. Are you okay going forward with Ms. Wood in court and not in your secret location?
Yes, sir, Your Honor. We've been communicating.
Good. If at any point you've got questions and want to speak to her privately, let me know. She can step outside and give you a call, okay?
All right, thank you.
Sounds like a plan. In a moment, Ms. Willingham, who is the other person on the screen you see there with the red glasses, she is going to put you under oath and then ask you a bunch of questions. You need to answer her questions truthfully and completely, and also let me know if at any point you've got questions. Will you do that?
Yes, sir.
Okay, let's get started.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Please state your true, correct, and legal name.
Mark Anthony Morris.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
37 and I received my GED.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss the case with your attorney?
No.
Are you satisfied with her services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding? Have you reviewed the indictment in this case? And do you waive formal reading of the indictment? Has your client been arrested on these charges? The state is unaware of any outstanding warrants related to these charges. Do you or your client know of any outstanding warrants related to these charges?
No.
Yeah, it's a lot of.
Do you understand you are entering a guilty plea to the following offenses? Count 1, aggravated assault, family violence, which has a minimum of 3 years and a maximum of 20. And count 8, receipt, possession, or transport of a firearm by a convicted felon or felony first offender, which has a minimum of 1 year and a maximum of 10.
Yes.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 160 days. You would be required to complete family violence intervention program. Sorry, Your Honor, going back to 60 hours of community service, have no weapons, and have no violent contact with the victim. Is this what was explained to you by your attorney?
Could you repeat that?
The state would recommend a sentence of 5 years to serve 160 days. You would be required to complete 60 hours of community service, have no weapons, complete family violence intervention program, and have no violent contact with the victim.
Yes.
Are you aware that the court does not have to accept that recommendation, and the court can sentence you to the maximum sentence on each charge and can run those sentences consecutively or one after the other?
Yes.
Do you understand that if you do not accept the court sentence, you may withdraw your plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
Are you on probation or parole for anything, anywhere?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a guilty plea?
Yes.
Do you further understand, because this is a family violence conviction, if you are found in possession of a firearm, you could be charged on the federal level?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of aggravated assault, family violence, and possession of a firearm by a convicted felon in indictment 25 SC 002463?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
And Your Honor, for the record, counts 2 through 7 of this indictment will be non-pressed. Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Your Honor, if this case were to proceed to trial, the state would expect to show that on October 16, 2023, Officer Lawson responded to 3000 Continental Colony Parkway Southwest in Fulton County in response to a domestic dispute. Upon arrival, Officer Lawson made contact with Shannon Jones, who advised that the father of her 2 children, Mark Morris, pointed a handgun at her. She advised that she and Morris got into a verbal altercation, which escalated to a physical altercation when Morris struck Shannon in the face with a closed fist. Morris then picked up the handgun, cocked it, and pointed it at Shannon, who was holding one of her 4 children in her arms. Morris then told Shannon to leave the apartment, which she did, and Morris followed Shannon to the parking lot with a handgun. Morris then got into his vehicle and left the location. A neighbor witnessed Shannon and Morris walking in the parking lot and saw Morris pointing the handgun at Shannon. And Your Honor, I have made multiple calls to Ms. Jones myself, and she has not called me back directly. She did speak with my investigator back in June, and at that time, she advised that they actually believed that this case had been resolved at some point.
It got dismissed.
Yes, and that was what my investigator explained to her. But she emphasized that because they thought the case was over, that she wanted nothing to do with it, that they were still in a relationship, and that she would rather us not contact her anymore. As stated, I have attempted to contact her multiple times. The first time I tried, her number was still the same. The second time, it either wasn't or I just didn't get a call back.
Got it. Okay. So she hasn't weighed in on this resolution directly. More implicitly, she's done with this prosecution.
Correct.
Okay. All right. Thank you. Pre-trial, did you get a chance to look up Mr. Morris's criminal history? Hey, Mr. York.
Good morning, sir. Yes,
Good
sir.
morning.
I found I'm kind of still skimming through it, but think I have everything.
All right, what you got?
24 cycles. And I'm just peeking through for convictions.
Your Honor, I can say that there is at least one conviction for a robbery. It's a Fulton County case, 15 SC 135844, and that was in November of 2019.
Okay. That's the basis for the felon in possession.
Yes, Your Honor.
Okay.
I am showing 7 felony convictions.
All right.
I'll go from the oldest. That's where I am currently. It was a 2008 APD theft by receiving stolen property conviction. A 2009 APD possession of cocaine conviction. Also 2009 APD willful obstruction of law enforcement officers by use of threats or violence conviction. (2009) APD possession of cocaine with intent to distribute conviction. (2010) APD possession of cocaine with intent to distribute. Two more. (2015) is a willful obstruction of law enforcement officers by use of threats or violence conviction. Same arrest, robbery conviction. And 2023 possession of a Schedule 1 or 2 controlled substance with intent to distribute conviction. Nothing further.
All right. And what's the most recent arrest that you've got?
Most recent arrest is October 22nd, 2024. It's APD simple battery, family violence.
Okay. Thank you. All right, Ms. Wood.
Thank you, Judge. So I shared the same information with Ms. that Ms. Willingham shared. I have not had direct contact with Ms. Jones. However, I know Mr. Morris is very eager to put this behind him and move forward. You accept the state's recommendation. He did serve 163 days from the 8th of 2023 until April the 18th of 2024. He did share with me proof that he's already enrolled in a family violence intervention program. I instructed him to make sure he gets that to probation as well. And then he also wanted to let me know that because of childcare and working, that he is concerned about doing the community service, and I'll explain to him that also probation will work with him. I know sometimes they allow people to pay a fee instead, but otherwise we ask that you accept the state's recommendation in this case.
All right. And tell me, Ms. Jones has what connection to Mr. Morris? They're still together. It's not just that they had, I mean, they remain an item.
Correct.
Interesting. Okay.
They have children together.
And they have kids together. So they are very interconnected. Mr. Morris, how long have you known Ms. Jones?
We actually from the same neighborhood, like elementary, on up, from the same neighborhood.
Got it. And do you guys share the same residence?
Yes.
Okay. How many kids do you two have?
We have 5 right now, and she has 2 older girls.
Older as in they are grown and working, or older as in like they're 5 and all your kids are really little?
15, 17.
Okay. Do they stay with you as well?
Just a 17-year-old.
Where's the 15-year-old?
In South Carolina with her grandmother.
Okay. And then you and Miss Jones have 5 kids together and they stay with you?
Yes.
How old is the oldest?
The 17-year-old.
And the youngest?
The youngest is 2. That's the one I had in court a couple of weeks ago.
Got it. Okay. All right. So it sounds like a lot of what we heard about from Mr. York was a while ago, a lot of convictions from 09 and 10. And I'm hopeful for all your kids that those are things that you've kind of put behind you. But you need to know that this criminal history is this kind of weight you drag behind you. And if you get in trouble again in the future, it's just going to make it more complicated. But it sounds like you're focused on family, and that's a good thing. What are you doing for work these days?
Captain D's.
Captain D's, what do you cook there or clean or what?
No, I cook.
Okay. How long have you been at Captain D's?
Well, I just got my job back when I got released from Rice Street. I said I got released on the 14th. They gave me back on the 1st of this month.
Why were you at Rice Street just a few weeks ago?
No, not August. It was not. When it was not August. June.
Oh, this is the ag assault. Okay.
Yeah.
Okay. All right. It sounds like those charges got dismissed.
Yep.
Okay. You and your brother got arrested for something?
Yeah, someone was shooting at us and they arrested everyone until they figure out what was going on with the case. And once they got the video and seen it was self-defense, the judge said there was no proper cause for us to be incarcerated.
Why was someone shooting at you?
Over a dispute.
Okay. All right. Well, I'm sure you didn't have a gun because you're a felon. So if any shots came from your direction, it would have been your brother or your bodyguard or something.
Yeah, from my brother.
All right, Mr. Morris, tell me what's the name of the program that you're doing right now?
I'm in Allison Family Violence.
Okay. How'd you find that one?
I went down to the misdemeanor place that they have on Mitchell Street, and they gave me a couple of online websites because of my money situation when I didn't have a job at the time.
Okay. All right. Well, hopefully it's a program that will get you credit for doing family violence intervention through felony probation. Ms. Simpson, Mr. Morris said he's on probation. Is that with DCS or is it a misdemeanor situation? Is it with the 23 SC case or the 15 SC case? Okay. But that sentence was after this conduct's from way back in, it's 2 years old. Okay. So this is not a revocation issue.
Yeah, the ag assault was the one that actually took the violence, but because it was dismissed that month.
Okay. All right. All right, Mr. Morris, I find there's a factual basis for your plea. You and Ms. Jones got into it. You need to not have guns in your household. That's going to end poorly for someone in some way. This time it cost you 163 days, and you never know when it could be worse than that. I also find that your plea is knowing and voluntary. Knowing means you've understood what we talked about. Voluntary means no one's forcing you to enter this plea. Do you agree with that?
Yes.
Any questions about anything we talked about?
Sure, Your Honor.
Okay. Ms. Wood, can someone in my office sign the indictment on your behalf? Ms. Willingham, can we sign for you?
Yes, Judge.
And Mr. Morris, can we sign your name indicating your guilty plea to counts 1 and 8?
Yes, sir.
All right, we'll do that. The state is dismissing counts 2 through 7, and I will sentence you on count 1 to 5 years to serve 5 months with a balance on probation. So that's 4 years and 7 months on probation. Special condition of probation number 1, complete a family violence intervention program. Then you need to complete that within the first year of your probation. Special condition number 2 is 60 hours of community service. You need to complete that within the first year of your probation. And probably most importantly, no violent contact with Ms. Shannon Jones. Apparently you guys still live together. You've got a mountain of kids. You're going to be spending time together. You need to be gentle with her. If she makes you upset, walk away. If you make her upset, walk away. Do something other than the kinds of things that have gotten you arrested a bunch of times. If we are together again while you're on probation and it involves you putting your hands on Ms. Jones in a way that she did not ask for, I'm gonna lock you up for a while. I'm just letting you know now, not because I'm a jerk, but because you know better and she deserves better. Okay?
Yes, sir.
Is your dad hearing this?
Yes, I am, Your Honor.
Good. All right.
I have one. I have
Your
one
dad looks
question.
like he hunts, so don't mess up because with that jacket on, he will find you and it won't end well.
I have a question about the community service hours though, because it's gonna be hard for me to do that while I have the 2-year-old with me. And then they get out of school. They get out of school on Fridays at 1:45. The 5-year-old and the 8-year-old, and throughout the Monday through Thursday they get out at 3:45.
So
And then
you're
I'm
busy.
stuck
Does
with
Miss
them.
Jones work also?
Yes, I'm stuck with them, and then once she get off, I have to go in.
Okay, I don't know about stuck with him, but you have the kids for a while, and then Miss Jones has the kids for a while. What does she do?
She work at nothing but cakes.
Well, that sounds better than Captain D's. All right. Well, so here's the deal. You need to try to complete the community service. You can do some of it on the weekends. You can do some of it when you're not, quote, stuck with the kids. But if you can show your probation officer, look, I'm not sitting home watching football. I am either taking care of kids or working. That's my life. Work kids, work kids. Then we can stretch it out. We'll figure something out. You're not gonna get revoked just because of community service.
I mean, she already knows. Like we was waiting to get this case resolved so we can go ahead on. Like she already knows I work back and forth and with the kids. Like I had already notified her last year or whenever this case first started before I took the probation for her. So we was just waiting to get this case resolved.
Okay, well, it's been resolved. And it sounds like you know your probation officer, which leads naturally into Ms. Simpson. What does Mr. Morris need to do to plug into probation now, since he's already plugged in?
So he needs to
Yeah,
report
she
his
had, she
Oh,
just
I'm
just
asking Ms. Simpson. You can see her on the screen there. She's with probation, so listen up.
He needs to report to his office on November the 4th.
Oh, he can't just call. He's got to go.
He can, but she would need to go over the conditions of this sentence and it won't be in there within 48 hours. It won't be in there yet.
Okay, so November 4th?
Yes,
As in go to the probation office?
preferably.
Okay, all right. How does he know when to go there?
He needs to report first thing in the morning. It's easier to report first thing in the morning because his day is an intake day.
Okay.
And there are a lot of people there.
It's a busy day. All right. So you need to go, you know where the probation office is?
Yes, I'm familiar with.
Good. You need to be there on November 4th. November 4th, that's next Tuesday. And that's when you'll do intake on these new charges.
All right.
Same. Where'd you go, Mr. Morris?
I was trying to add it to the calendar.
Oh, okay, that's fine. I don't need to see you anymore. So that's the deal. Your sentence on count 8 is the very same as with count 1. So that's the 5 years to serve 5 months, balanced, probated, same conditions, etc. Ms. Willingham, anything else from the state?
Nothing further from the state.
Ms. Wood? All right, Mr. Morris, any questions?
No, sir, Your Honor.
All right, November 4th, go to probation. Good luck with Captain D's, all those kids. Please be nice to Miss Jones, all right?
And thank you, Your Honor.
Yeah, you are. All right, see ya.
Have a good one.
Judge, that concludes my business.
Yes, ma'am. Let's bring Mr. Maloney out, please. He should be here now.
Brown, I compliment the go to the application at my office. August, but I will get a waiver in based on our conversation.
You think he will qualify now, and assuming he does, then you'll do a waiver and we can move it forward. Great. Mr. Brown, before you go. You live on Lakeside Drive, Unit 2001? Okay, good. You'll get stuff in the mail. More importantly, Ms. Rios will be in touch with you. Did you give her your phone number? Okay, then go to their office, file in to make sure you qualify, assuming you do. Ms. Rios will take over from there, okay? You too.
That's all I have. That will be excused.
Yes, ma'am. Hello, Mr. Maloney. How are you? You have something for me? Okay, just a sec. I'll take that. I want to see, I may have jumped a gun here. Yeah, nope, Ms. Broderick is on. Hey, Ms. Broderick.
Good morning, Your Honor. How are you?
I am well, and I very much appreciate you jumping on. I know this is Mr. Regis's case. You guys are a team, but he is unsurprisingly stuck somewhere else. And you are taking a moment out of your busy day to plug in so we can do the arraignment for Mr. Maloney.
Yes, Your Honor.
Mr. Maloney, I will take what you got in a minute, but I want to cover the business part of things first. You and I met before. Mr. Regis is still your lawyer. He has not abandoned you. He is in another courtroom doing something else. A colleague of his, Ms. Broderick, you can see on the screen there. Today is just a new arraignment date. There's a re-indictment of your case. A few defendants were added. Some other charges were added. Mr. Abate, were there any new charges added as to Mr. Maloney?
My recollection, no, Your Honor.
Okay, so sort of a merger of cases. So you're facing the same situation, and you've got the same lawyer. We just kind of have to reset the process. Your lawyer will get discovery. It's going to be on a hard drive. He will review that initially by himself and then with you, and we'll make sure we continue to move the case along. Okay? Do you have any questions about that little bit I said about this arraignment? Okay, Ms. Broderick, is Mr. Maloney waiving arraignment, and we can get you that waiver form if Mr. Regis hasn't already filed one and entering a not guilty plea?
Well, Your Honor, I would like to ask him, Mr. Maloney, do you want the judge to read the charges against you, or do you want to forego him reading it because you already know what you've been charged with and just enter your not guilty plea?
Did he say that as the charge was added, I didn't have no added?
Correct. It's the same charges. So if you knew them from before, it's the same charges. There's some new names in the indictment, and there are some new charges, but they're not your new charges. So is that your way of saying you don't need to read them into the record, Judge? You'll waive arraignment? Okay, got it. Ms. Broderick, should we send to you or should we send to Mr. Regis our standard waiver form?
Your Honor, you can send it to me.
Great. I'll have Ms. Nelson do that this morning, just so we can get it in the docket. Do you happen to know, Mr. Howell sent an email out to all the defense attorneys saying, please deliver a hard drive and we'll put discovery on it. And a few of the defense attorneys sent an email back that wasn't required. They just were put on notice. Do you know if Mr. Regis has gotten a hard drive over to the DA's office?
Mr. Regis's investigator has just informed me that it's already with the DA's office.
Fantastic. Well, they are loading up those hard drives, and then I'm sure the investigator will grab it, and then your team, Mr. Maloney, will have the discovery, and then they'll be getting with you on that. Ms. Singleton, was there anything you wanted to add about Mr. Maloney?
No, Your Honor. Other than he has the awards that he wanted the court to see.
Okay, this is what he wanted me to, okay.
Well, actually, I guess I do. He was Homecoming King award, as well as completing the PREA. He also has a report card that he would like Your Honor to see that's all A's and B's. He participated in the Peace program, and he also was Student of the Month for the month of September. So he did want the court to have these, as well as he wrote a letter. I sent a picture of it to Ms. Rogers so that Ms. Rogers may be able to see it.
Okay.
So,
Mr. Maloney, tell me what is involved in being selected the homecoming king. It's probably a different process based on where you are. I'm curious, is that the other people involved thought you were a good leader, or you were the cutest, or what?
They told me it's not about looks, it's about structure, leadership, discipline, and honesty.
And is the voting group other young men at the YDC, or is it the supervisors, or who?
I don't have information on that. I don't remember.
Okay, you got it.
Yes, sir.
All right, well, congratulations. It sounds like you are making the most of what is a complicated situation. I'm happy to look at all those. Did you want me to keep those or to see them, but those are your copies? Okay, I'll take a look at those.
You want the letter, Your Honor? Did a picture, but I wasn't sure.
No, I'm happy to take the letter. We need to make sure the prosecutor gets a copy of it, or he can read it. Why don't we have Mr. Abadi read it first? Did particularly well in personal financial literacy. What's that?
Personal finance, as in housing, personal income, and it's really about house mortgage, personal income, and tax payments.
Okay.
Mr. Maloney, I know today is my first day meeting you, but I would like to say I am very proud of you. I have two sons who are early 20s, and I'm a Boy Scout leader, and my son is an Eagle Scout. And the fact that you want people to see your accomplishments is really something to be proud of.
Okay. I bet Ms. Broderick would like you to help her sons with personal financial literacy.
Yes.
That's
That is
fantastic.
one of the classes that they have to take as Boy Scouts. They have to take financial literacy.
Excellent. Well, good. So Mr. Maloney, I will read the letter, and we'll make sure Mr. Regis gets that discovery. He will then get with you, he and or the investigator will get with you, and that'll enable us to keep moving the case forward. Mr. Hiles, who is one of the prosecutors, assures me no more indictments. This is the final version of all this stuff. Okay? Do you have any questions about anything?
I thought I was coming back at the second time. My bond hearing, as in the first time I didn't have an immediate address. Now I have an address, so I was like, I'm forward with that.
Okay, so what you should do when you next talk with Mr. Regis or anyone who works with Mr. Regis is share that with them, and they may want to file a new motion. I've decided for now, no bond, but those are things that we revisit as time passes. I will tell you that the stack of documents that you provided would be a reason to think about it again, because you're doing well and demonstrating that you might be able to, under certain conditions of bond, stay out of trouble. But there are a lot of factors involved, and having that new address may be something else that Mr. Regis wants to advocate for, because I know that was one of my concerns is, well, going back to the same place isn't necessarily what anyone wants to have happen. So you have a very good advocate on your behalf in the form of Mr. Regis. You are doing a very good job of advocating for yourself by doing as well as you are in what is, I know, a complicated place to be. So I appreciate you asking that, and we will see you again when Mr. Regis figures out what the right next step is. Okay? Ms. Broderick, anything else on behalf of Mr. Maloney?
No, Your Honor, I will make sure he is caught up to speed on what happened here today and the court's position on the potential for reviewing the bond discussion.
Okay. Thank you for doing that, and thank you again for jumping in. I'll have Ms. Nelson send you that waiver of arraignment form. We can get that e-file. That'll move things along. Mr. Abadi, any?
I'm sorry. Can you please have Ms. Broderick put that in the chat, her email?
Yes.
Sure. You bet. Anything from the state? Okay. All right, Mr. Maloney, good seeing you. All right, I think what we have left is to do Mr. Arnold and then to talk about the sentencing for the other person.
Yes.
All right,
Mr. Arnold first.
sure.
Robin, do you have this here that are on yet?
I don't, I just looked since we were pivoting away. You had said 11,
Yes.
so it's not quite 11 yet.
Yeah, okay.
I'm assuming you're covering everything now since your colleagues all bailed?
I'm a pro.
This is negotiable.
Hey, Mr. Arnold, come on up to the podium, please. All right, let's get on the record in Mr. Arnold's case. It's 11 SC 102592. It's a burglary case from long ago. I'm guessing Judge Downs sentenced you because you got 1,000,000 years of probation.
Yes, sir.
Okay, you got about 5.5 years of probation remaining. And I signed a warrant back in July of last year. So it's an old warrant that said you had failed to report. Basically, we had lost track of you. And that may have been you were having trouble with housing, or maybe you moved and forgot to tell folks. But now we're together again. And I think you've been in jail now almost a couple months.
Yes.
Okay. I'm going to ask your lawyer a few questions, and then she may want you to share some things. I'm going to hear from the prosecutor, and then I may have a few questions for the probation officer, okay?
Yes.
All right, so Ms. Wood, is Mr. Arnold admitting to the failure to report?
Yes, sir.
Okay. The copy of the warrant I have, it just said he had a hearing and was released. That's all. There's part I couldn't read. So it's basically a failure to report. It says something about failure to complete, Grady Act. So he was supposed to be connected with the ACT team. Talk to me about Mr. Arnold.
He has actually been in custody for 62 days. He works with PAD. He is, my understanding, he's going to be reconnecting with PAD. Although he does have another case that he's going to need to work through before he actually leaves the jail, judge.
Okay.
But I am not going to get in the middle of that because I know he and his attorney on that case are working very diligently. So yeah, we would ask that you revoke 60 days, reinstate to probation. Yeah, that's all we have for this case.
What are the new charges?
That's my shopping.
All right. Is that a case that has been indicted?
It was indicted as of last week,
Okay.
not to us.
And when you say that Mr. Arnold is involved with PAD, in what way is he involved? What services are they providing?
They gonna help me get apartment on my own place. I was living out there in the streets.
Okay. I had an address for you in Lithonia. Did you used to live out on Marbot Farms?
Yes, sir.
What was there?
With my sister Jeanette Williamson.
Okay. Can you not live there anymore?
No, sir, I don't want to live there anymore.
What happened there? Bad cook?
We don't get along.
Oh, okay. All right. So where would you stay in the interim if PAD can't get you an apartment right away?
They gonna put me on the center. They gonna put me on the center program.
Okay.
And I can leave them drugs out smoking weed.
Have you worked with PAD before?
Yes,
For how long?
3.5 years.
Okay.
And then I was going to 10 Park, like down the grade, and they were gonna help me get
Yeah, so you were supposed to plug in with the Grady Act team. Any reason why you didn't do that?
I've been locked up.
Oh, well, that would be one reason. Have you worked with Grady Act before?
I've been going to my program, yes, sir.
Okay, and does that work for you?
Yes, sir.
All right. Does Mr. Arnold have a bond on his new case?
Yes, I'm not sure it's one you may judge, but he has one set.
Okay, all right. Mr. Abadi, I'm interested in your input. I am wondering whether we revoke and continue Mr. Arnold on probation, or if we revoke and close out a case from 2011. And some judge may decide that the new case merits additional probation, but you don't get to answer. Actually, Ms. Simpson is going to answer.
Actually, you would go that way. I'm just gonna ask that you reinstate ours. He does have a probation case in Cobb County because he has a new case with them. But our case actually extends past the Cobb County case.
But then he also has a new Fulton County case.
Yes, that part I wasn't aware of. I only knew about the Cobb County sentence. If you want to close this one out, I mean, you feel
How much time is left in the Cobb case?
the Cobb County case, expires September of next year.
Okay, so he's got a little less than a year left in Cobb, 5+ years here, and then TBD with this new shoplifting case. It's conceivable that that's one of those, you got to serve a year shoplifting cases, although I guess that law changed a little bit.
Because we don't know how that one is gonna turn out.
Right.
Especially with him not having a stable residence.
Okay, you think maintaining him on probation is better because at least there's some resource connection?
Yes.
Okay, all right. Mr. Abadi?
They were both closed.
Okay,
I'll defer to the.
okay. So Mr. Arnold, I am going to revoke, well, did you want to add anything? I did hear some from you. I didn't mean to keep you from saying more if there was more you wanted.
I get income, and if I would have to pay any money to get at, I will. My bond is $2,000. That's $200 to get out, and I got to go there to jail.
Okay,
So if I can pay the jail the money to pay that, I would be glad to pay it. And I would not get in no more trouble.
Huh. All right, well, don't say that unless you know you really won't. And
Yeah, I'm 63 years old, so I got that.
right, but desperate times lead to desperate measures, and I don't want you to promise something you can't do. But what I'm going to do, Mr. Arnold, is revoke 90 days of your probation, and then terminate your probation in this case. So we'll close this one out. You still have probation in Cobb. That'll run through September of next year, and you've got these new charges that you'll need to work through, okay?
Yes, sir.
All right. Have you ever, what kind of drug treatment have you received, Mr. Arnold?
Well, it been years ago. Boulevard, I was at, it been back in the 80s.
Yeah, that goes way back. Okay. All right. Okay. Well, that's what we're going to do. And we're going to say farewell to the burglary from 2011. Okay.
Yes, sir.
All right. See you around.
Okay, thank you, Lord, bless you.
Thank you, Judge.
Yes, ma'am. It was 2-1, Miss Simpson.
already figured you would, because I know you don't have cases.
It's not that I don't like, it's just, each situation is different, and with a little bit of time left in Cobb and then these new charges, he's gonna be entangled in the system. Let's cut this line. And to his point, he is 62 or 3, so.
Still in between houses.
I know. We don't have an ideal support network.
I heard that was nearly one of them.
Forgot about that bias. Hey, Marietta RYDC is on. I don't. I just see Marietta RYDC. Okay, great.
Sorry. Okay.
Yes. Yeah. Any LaGrua sentence. How can we?
Okay, Ms. Williams should be coming up.
Great.
Sorry.
Hey, are you Mr. Chambliss?
Yes, sir.
Great. I'm Judge McBurney. We're waiting. Your lawyer is going to hop on in just a sec, and then we're going to have a quick conversation.
Yes, sir.
And thank you folks at Marietta for getting Mr. Chambliss on.
You're welcome.
And Judge, for Mr. Moment, I guess there wasn't a response to Ms. Wood's email, stated no objection to what's being requested if you don't want to bring him out, just tell him he's getting the required credit for time served that he's previously served.
Well, I'll let him, I'll tell him, but actually, there's nothing we can do about credit from other jurisdictions. He's entitled to it statutorily. I just don't think that our custodian, the Fulton Sheriff, is authorized to say, oh, and you get 30 days for the time you were in Clayton. That's not their job. And when he hits Jackson, then these other custodian affidavits need to come in to get credit. But Ms. Wood's point about getting credit for every day he's been in custody, regardless of the charge from the time of this case, is correct. I just don't think that there is a obligation or even the authority of this custodian to declare the credit for time spent in other jurisdictions. So I think that's the disconnect. But if you've seen that in the past, then we need the sheriff to do it differently. I don't think I've ever seen Fulton say, you get 180 days from us, 97 days from Cobb. And this guy, I mean, he's like a passport for all the different places he was getting credit. Do you think that,
I think the job was very nice, by the way.
Good.
Trying to work with me about this. They just need it from the court. So I never proposed order. I'm going to do everything.
Okay. And they'll put in their affidavit credit from other jurisdictions, but they verify, like they call Cobb and say, when was Marcus Moment here?
And I've got the crucifix.
Okay, I didn't realize that they compile, and maybe that is the last custodian has the job of pulling together all those threads. Okay, okay. And Mr. Body's not gonna object? Tomorrow is Deputy Gordon's birthday. We can celebrate more this way. It's hard with the jail Zoom count. Like those guys are grumpy in the booths. They're not gonna want to sing happy birthday to you. So figured we'd just be happy for you today. Well, there's cause to celebrate. The Dolphins won. Yeah. Rubbed a certain team all over the field. Did Kent State win? See, look at what a weekend for you. And the Eagles won? They knew it was your sort of birthday weekend. How are you celebrating tomorrow? You're not celebrating tomorrow? Does the sheriff like let you just stay on the 9th floor, or you wish?
Why not gonna work tomorrow?
Oh. Well, you should have taken yesterday off. That's what it felt like. Might not come to work tomorrow. Oh, Ms. Williams is on. Great. Good morning, Ms. Williams.
Morning, Judge.
Thank you for joining us. Let me add you. There you are. So we've got Mr. Chambliss appearing from Marietta RYDC, Ms. Williams from her office. And this is arraignment on 25 SC 006076. We had a couple other arraignments already today, Mr. Maloney and Mr. Shannon. They both waived arraignment. I don't think this is a new situation for Mr. Chambliss. This is a indictment that consolidated a couple cases, but I don't want to speak out of turn. So let's just work through it from the beginning. Ms. Williams, is Mr. Chambliss wanting to be formally arraigned, or are you going to waive arraignment on his behalf?
Your Honor, we're going to waive arraignment on his behalf, enter a plea of not guilty, and ask for 10 days to file motions.
So you'll get more than that. I will, if you can send your email address to Ms. Nelson, you'll see her on the participant list there. If you put that in the chat, she will send you our waiver of arraignment form. Okay. And if you fill that out, she will e-file it. That will yield a scheduling order that will have a deadline for the state to get you discovery. I know that's already underway. I saw Mr. Hiles's email. Did you get a hard drive over to that office?
Yes, Your Honor. My understanding is that that was taken care of in my absence.
Great. So they are filling those hard drives with all the discovery. That'll get back to you. They've got a deadline to provide that discovery. Your motions deadline doesn't start. It's after receipt of discovery. So you don't need to worry about 10 days. It's more than that. You need to get the discovery first, and then you can file motions.
Okay.
Mr. Chambliss, do you have any questions for me about what's going on?
Yes, sir.
Okay. Your lawyer is going to get discovery. It's going to be a whole bunch of stuff. She will look through it, and then she will figure out a time to talk with you about what's in there. Some of it may be good in the sense that it says someone else was involved and not you. Some of it may be bad. It could be a video of you doing something. Who knows? Ms. Williams will look at all that. She'll share it with you, and then you and she will figure out a plan of action. I will see you next, Mr. Chambliss, either because there are motions that need to be argued, or because we reach this point called final plea, which is the last time to try to work the case out where you can withdraw your plea if you don't like the sentence you get. Given what you're charged with, I don't know that that's how this is going to play out, but I know you've got a good advocate on your behalf. Ms. Williams will be seeing what she can do and moving your case along. Mr. Abadi, anything from the state? Okay. Ms. Williams, please let me know if there is a delay in getting the discovery. Assuming the state gets you that discovery, then we're off and running. If for some reason you or your investigator are not getting that hard drive back, I need to know that so that I can slow things down a little bit and ask the state why they're not getting you what you need to move things along. Okay?
Will do, Your Honor. Thank you.
All right. Well, if there's nothing else, that is it for today, Mr. Chambliss, and we'll see you soon.
Thank you, Your Honor.
All right. Thanks, Ms. Williams. And thanks, Marietta. That was it. Short and sweet.
Cool.
And they're gone. Boom. You're welcome. Thank you. Our tomorrow is all adult defendants.
I'll be here for unique.
Pardon me?
For unique, I'll be here for unique, John.
Okay. And unique is male or female? Female. Is that the only female defendant in the case? Well, at least the only female juvenile.
Yes, and it's from my understanding, there's a pending bond motion.
Okay.
It was filed on the old indictment. But
Okay.
when they called me yesterday.
Oh, okay. Does Mr. Abadi know that we may be talking about bond with Unique Jones?
I do not know.
I'll tell him.
Which case?
Same case. There's a defendant named Unique Jones. I think Mr. Luemba represents her. And Ms. Singleton was saying that there's a bond motion out there. I don't know what the calendar says. Okay.
He filed it a little while ago. So I was just coming.
He can sit wherever's easier for you. He can just sit at the table. Okay. I don't know. That's what Ms. Singleton flagged. So Ms. Jones is a juvenile, so she will not be
She's 17.
She's 17. You're involved because she was a juvenile. And so she'll be coming from she'll be zooming in from ACDC, I guess.
She's made a couple of stops. She's somewhere else.
Oh.
She's not there.
Huh.
She's somewhere else. I hope they know where.
Okay.
I have to look to my
Yeah.
notes to see which facility.
We'll see if she joins us.
She's somewhere else.
Okay.
So I didn't know if she was produced or not. I'll speak with Ms. Nelson.
Yeah, please speak with Ms. Nelson and we'll figure that out. Thank you. All right. I think we're done with stuff that needs to be on the record. Ms. Rivers? All right, let's talk about Mr. Moment.
Yes.
I'm ready. So Mr. Moment, Ms. Wood reached out to me expressing concern that you were not getting credit for all the time you served in the many different jails you spent time in your cases. And I assured her that you are legally entitled to all of it as long as it's time after the date of the incident. And it sounds like it is. We're just working through whose job it is to document that you serve time in these different places. Ms. Wood?
Yes, Judge. So, the current disposition obviously just says the time should be determined by the custodian.
Which is a safe thing to say.
Sure. The nice folks over at the records department at the jail, so they've only gotten him down for serving something like 55 days, I think it said. Which doesn't even encompass all of the days that he was in Fulton when you add them up.
Oh.
And so I spoke with them last week, like, oh, it's just going down. And they're very nice, and they, you know, the dates for the other places are actually in the order, then you can credit it, but as of right now, they're just going off of what they can see, which, you know, I understand.
Why would they not see all the Fulton time?
I don't think they clicked, like, I think they're just I don't think they like went all the way back.
Okay.
But I mean, I'm happy to like send them booking numbers or whatever they need to see all of that. I did go ahead and get proofs of incarceration from Clayton, Cook County, and Douglas, which do reflect the dates that I shared in my motion. And I'm just asking the court, so obviously, OCGA 17 and 11, he's entitled to every single day he spent in custody. I think the confusion comes down to what we've already talked about in the emails, which is actually who is responsible for putting that time together.
Right. Did you ask anyone at the Department of Corrections?
I have not made it that far.
Okay.
Because from my math, he will not actually have to go to Jackson.
Oh, so this math is even more important, is that it would keep him.
Yes, Judge, because my fear now, they've already filed an affidavit of custodian. When I spoke to them on Friday, they said he is ready to be shipped out.
Mhm.
So that's why I was like.
Sure, because if they only have 50-something days, there's this big gap.
Correct, because right now, if you talk to someone at records, they're saying that he has to go down the road for 18 months.
Okay.
And he's already done all of that, even though there is still a whole chunk for Cook County, who knows if Cook County is actually going through with that. So I have prepared an order that I will share with the court, and I've got the affidavits I will also share, and that's our request.
And records has said if it's in the final disposition that he's supposed to get credit for certain days, they honor that?
Yes.
And they put it in their affidavit, or they just do some math and say, oh, look, he's done 18 months and the sentence is for 18 months.
I believe, I will go back and look at the email that I received, but I believe if they receive the affidavits and they'll put it, I don't know if you've seen an affidavit of custodian recently. It's got like different lines you can fill out. It's my understanding they would be able to then put in there the dates and from what county jails.
Right. So why don't we see, I'll sign whatever you need if it is appropriate to sign it, but have you sent to them the proof of incarceration that you have gathered from these different places to say, all right, now, given all that, what is your math?
I haven't done that yet, because I was gonna see what we had to say here today.
Okay. All right. Mr. Body, it sounds like the state doesn't object to any steps being taken that get Mr. Moment the credit to which he's statutorily entitled.
That's correct,
Okay, so we don't need to drag them through it. I will do what the records team needs to make it official. But why don't you work with them, sharing with them everything you've gathered and pointing to them the booking numbers they need to look at? Because of course, step one would be get the Fulton time right. And then they would add to it the time represented by all these other affidavits. And if they look at that and say, you're right, but ... we need something from the judge, let me know and we'll do it. I'm trying to take Ms. Nelson out of the business of being the person who needs to figure out what the time served has been. The direction from the appellate courts has been, check that box that says the custodian figures it out. That's all fine and good if the custodian gets it right. And here they're not, and I don't blame the Fulton people. They don't have a way of knowing, did Mr. Moment spend 6 months in Douglas County Jail? That's not, their focus is how much did he spend here in Fulton? And even that number they didn't get right. So I guess if you or Ms. Rios or someone comes with the proof of incarceration, I'm more comfortable saying to Ms. Nelson, hey, let's put those date ranges in there. What we have run into sometime, not so much with you, but a lawyer saying, oh, he did 2 months in Cobb County. I think it was like March to May. And what's Ms. Nelson supposed to do? And I don't, one, it shouldn't be guesswork, but two, is a little bit of an expansion of our role to be saying you get credit for time outside of this jurisdiction. Not because it's improper, just that's not the space in which we operate.
Sure. And I think it's our office position that, you know, Forest is relatively new. It was decided on my birthday this year. And I think 17-10-12 actually just doesn't make it super clear whose responsibility this is.
That's right. And we can own it. And especially if record says, if you get us these affidavits from the other jurisdictions, that they'll then put it in their, I'll call it master affidavits. And this is, he's coming from us. So we are the custodian. And so there should be a Douglas component and a Cook component. If they say that's their job, great. And then we can go back to checking the box of the custodian, we'll calculate it. If they say there's either we don't have the person power to do that or that's not our job, then I don't want to litigate it with them. We can say, if you get the affidavits and Ms. Nelson and I can eyeball them, then we'll put in the final disposition. You get credit for this date range from Cobb and this date range from Douglas. Just, and is putting the burden in your lap, but you're the one with the client who was traveling a lot. Does that work? I don't want you to leave here thinking, what a pain.
I can do that. I will, I'm drafting an email right now to the ladies at Records, and then if they have any pushback, I will send you my proposal.
Can you copy Ms. Nelson on the email to Records? Great. Yeah, and if they have pushback, Mr. Moment, I don't want you to leave here despair. This will work out in the end. You are sort of a test case for us because you were so popular and went to so many jurisdictions. We need to figure out going forward when we get our next Mr. Moment, how does that person's lawyer get the documentation? And then is it something the court deals with? Is it something that the sheriff has to deal with? Or worst case scenario, do you have to get all the way down to Jackson only to show them, I already did 19 months and the judge only sentenced me to 18. Like, oh, our bad. And then they release you. That seems real inefficient. So we'll sort, that won't be what happens to you. We just need to figure out if there is a routine we can get in place. Did you have anything you wanted to add on that?
No, I was just coming to listen.
Okay. Did you like what you heard?
I have an understanding.
That's not answering my question though.
We don't have an answer.
Okay, we don't. All right.
Thank you, Judge.
You're welcome. Keep me posted, please.
What were we doing in this case? The one that
Mr. Roberts?
right was.
She was gonna get with you when she was done with court in Douglas County to figure out a day she could be here soon and we could produce Mr. Rob, so it wouldn't be a published calendar. That's what I thought at first, but what she said in the end was, I'll get with Ms. Nelson when I'm done with court. So hopefully she remembers that.
So did you get my email?
Mr. Roberts is?
Yeah, because he's got another case that was, Judge Ingram's. Yeah.
Well, we got that. Oh, he has two from Ingram?
I thought one was ours alone.
So,
The transfer. But one of them is going on.
well, that's probably the probation one and it should stay with her. Our policy isn't that you transfer your probation case. The one ending in 250,
Yes.
that's a closed case.
He also has another one, 24 SC 002307.
And that's a closed case for which he's on probation? Oh, yes, we would handle that as well. But that's not, it's not that it gets transferred to us, it's just, it needs to be on the calendar listed as a revocation.
We had 3 on calendars?
We did, but two of them are, open cases.
Okay, so one more probation.
One more revocation. He's a busy little angry guy. He's got a bunch of time. Okay. All right. This gang case. Do you guys have one of the defendants in the gang case? Zero. Typical. All right. I think we are done. This.
What was going on with